eyes, well, maybe nobody meant it, but you could have predicted that this might happen by drag racing. You could have predicted that someone could be killed.
When I was a kid, I did all sorts of things that would today get me into trouble.
I heard that.
And the thought in my mind is that you have more of a danger today than perhaps in the past of getting into serious legal trouble for things like going into abandoned houses where it might be fun to play, or in some towns there's actually curfew, right? Just staying
That's
out
right.
beyond curfew. I'm thinking of mischief night and doing things that at the time seemed fun and were accepted in society, and today we're a little more stringent. What are your thoughts on that?
I think 40 or 50 years ago when you were a child, there was a lot more freedom, less prosecution. I think today there's a little bit more prosecution. I think there's been more publicity with cases like the Columbine murders.
Right.
I think there's more publicity. In Sussex County, we had the pizza murders approximately 10 years ago, where one of the defendants in that case was a juvenile. Briefly, the facts of that case were that a 17-year-old and an 18-year-old, I believe were their ages, were eventually convicted of murdering someone.
Right.
And when that happened, I think the system took a closer look at juveniles and how they're being treated. When I was in school not too long ago, there were no law enforcement officers in schools. Today there's law enforcement in just about every school. So I think there's a little bit more attention to crimes that are committed by juveniles. I think we want to figure out whether or not this was just a stupid act by someone who wasn't thinking clearly, or whether or not this is someone that's going to graduate to become a criminal. And the system wants to get involved and try to protect that person from graduating to become a criminal.
Now, you've been practicing for a long time. You were there when I was a kid. You'll be there when my children are there.
Touche.
So I want to know, what happens with going before the judge and trying to negotiate before this imposition of sentence? We were talking about detention, we were talking about the possibility of house arrest, of all these different options. Can you go and say, well, Your Honor, can we talk off to the side and come up with different...
Generally, that doesn't happen. Generally, what happens is once you figure out where the child is going to be, whether they're home on house arrest or they're in detention, there begins a process with the prosecutor's office. The prosecutor's office will give you the evidence called discovery. And we'll sift through that. We'll find out if there's any legal defenses that are available. And we'll discuss that with the client. And we'll compare the police officer's investigation to our client's version of the events. And we'll look for legal defenses that are available. Maybe motions have to be filed, motions to suppress or other motions. But the court will routinely bring you back for a case management conference. If you're in detention, you have to come back within 2 weeks. The next time you have to come back is within 3 weeks. So one of your earlier questions is, how long can you be in detention? Initially it's 2 weeks, and we can review whether or not you should still be there. And if you are, you're going to come back again in 3 weeks. But during those case management conferences, the prosecutor and the defense attorney will try to work toward a plea agreement. I would say probably 90% or more of juvenile delinquency cases are not tried.
Okay, so let's do two things. One, compare that to adults. Would you say 90% or more of adult cases are not tried?
Yes.
So it's parallel, it's similar.
I would say it's very similar, that's right. I think there's more adult cases, and there's typically more assistant prosecutors assigned to handle adult criminal complaints. Juvenile delinquency complaints are less than adult complaints, but the mechanism is generally the same. They will come back for a conference. In adult court, there's a different procedure where the case can be presented to a grand jury. There is no such mechanism for juveniles. The purpose of the grand jury is to determine whether or not there's enough evidence to continue with the case, to continue with the prosecution. Juveniles don't have that.
Well, the second part of my question is, are there special prosecutors who deal just with juvenile cases, or is it the regular assistant prosecutor assigned adult cases and juvenile cases?
Every county prosecutor's office has assistant prosecutors, and generally speaking, they all have different duties. One assistant prosecutor might handle drug cases. One assistant prosecutor may be in major crimes. Another assistant prosecutor may handle juvenile delinquency cases. Another one may handle domestic disputes. So generally there is at least one or more assistant prosecutors that are assigned to juvenile delinquency complaints.
Now, getting back to your point about grand juries, so if a prosecutor is assigned and then charges are going to be brought, a complaint, as you mentioned, has to be formally submitted before, or the child has to be released. It's submitted, going through trial. Why is there no grand jury benefit for a juvenile when we think of judges as being made of sterner stuff than average jurors? And you might be able to convince a jury either through emotional appeals or through legal reasoning that you might not be able to convince a judge who's heard it all before.
The purpose of the grand jury, like I said, is to determine if there's enough evidence to continue.
Right.
With a juvenile, you have the right to what's called a probable cause hearing. So you can present to the court what evidence the prosecutor's office has, and based on that evidence, is there enough to go forward? So with adults, you have the benefit of a bunch of strangers getting together and hearing the case for the first time. That is the grand jury. For a juvenile, juvenile proceedings are closed to the public. They are confidential. Generally speaking, the court's open to the public. You can go to Superior Court any day and watch a civil case or a family case or a criminal case. But there's certain cases you can't go in and see. You can't go in and see a juvenile delinquency case, it's closed to the public. You can't go in and see a DIFUS case, that's closed to the public. So those are some examples. So I think when you compare the grand jury to a probable cause, we're asking a judge to determine whether or not there's enough evidence. We're not asking a bunch of strangers to determine that.
Do you think that there's a benefit to that that is outweighed by the burden of not having, obviously a juror of your peers, if you're 11, 12, 15 years old, might not be appropriate, but do you think that it's more difficult to try and convince a judge at a probable cause hearing than it is a panel of jurors at a grand jury?
No, not necessarily, because when you go before the grand jury as an adult, as a defendant, you're not often notified that the case is going before the grand jury. It's a secret proceeding. You're not entitled to participate in that proceeding. There's some disagreement on that, but the general theory is that you're not entitled to participate in that proceeding, and so you're indicted without even knowing that your case is being presented. With a juvenile, I think it's a little bit of a higher standard. We want a judge to look at all the factors. We want him to look at the ties to the community. We want him to look at the age of the juvenile when you're doing a probable cause hearing.
I see.
And ultimately, when you have to decide the issue, when you have to decide whether or not if a trial is necessary, whether or not a crime has been committed, the juvenile does not have a jury. They have a judge. Again, because it's a confidential proceeding.
We only have a few moments left, and we could discuss more of this in greater detail in another program. But just in closing, I'd like to know if things go well and there's an acquittal, if we have the not guilty verdict, then the juvenile gets to go home, everything's done.
That's right.
However, in 30 seconds, if you could give us 2 or 3 alternatives of what happens if we have a guilty verdict.
They could be placed in detention, depending on the severity of the crime. They can be placed on probation. They can be required to have mental health evaluations, community service, pay restitution. Those are some of the potential consequences for a conviction or what's called an adjudication of delinquency.
Last question, and then we have to bring this program to a close. If an individual makes a mistake, does something stupid as a juvenile, and 5 or 6 years later is now an adult and doesn't want that to reflect poorly on them, do they have to share information with potential employers and others about the past mistakes they made as a teenager?
It depends on the question that the employer asked. If the employer asks, have you ever been convicted of a crime, juveniles are not charged with crimes. They're charged with delinquent acts. So they can answer no. They're not convicted of a crime. But if they're asked if they've been adjudicated delinquent, then they have to answer that honestly.
I see.
Those records are not open to the public. It would be hard to verify.
And thank you for sharing your expertise on this matter. I look forward to having you on again.
It was my pleasure. Thank you for having me.
Thank you for tuning in to LawTalkToday.tv. I'm Dan Agatino, your host.